This is the fifth series of Straight to the Questions, 50 most frequently asked MCQs on Indian Evidence Act 1872 by Ask Me Anything. It is very important for all India Board examination and judicial service examination. If you want to watch the similar MCQs on Criminal Procedure Court, Indian Penal Code, Constitutional Law, Law of Tort, Motor Vehicles Act, then click the I button or go to the link given below in a description. Before coming to the questions, let us try to understand brief notes on Indian Evidence Act 1872. It is one of the important branches of procedural law or adjective law. In India, law relating to the principles of evidence is governed by Indian Evidence Act 1872 and is applicable to both criminal and civil cases, as it is applicable to all judicial proceedings. At present, Indian Evidence Act 1872 has 167 sections divided into 11 chapters under 3 parts. Okay, coming to the question. Question number 1 says, to whom the burden of proving a fact lies? Here, the normal rule in the law of evidence is that the burden of proving a fact lies on the party who alleges a fact. Question number 2, what is a fact in issue? Fact in issue are those facts which are alleged by one party and denied by other party in the pleading in a civil cases and alleged by prosecutions and denied by the accused in criminal cases. It is provided in section 3 of Indian Evidence Act 1872. Let us see one example of fact in issue. For example, A accused B of theft, but B denies the performance of any such activity. Here the questions of whether B had committed theft or not is a fact in issue. Coming to question number 3, what is the basic difference between confessions and admissions? Here, all confessions are admissions, but all admissions are not confessions. That means confession refers to a formal statement by which the accused admits his guilt of a crime, and admission refers to the acknowledgement of a fact under discussion or a material fact in a lawsuit. Admission is defined under section 17 of Indian Evidence Act 1872, but confession is not defined in the act. Let us see some basic difference of these confessions and admissions. If we look to the meaning, confession refers to a formal statement by which the accused admits his guilt of a crime. But if you look on the other side, admission refers to the acknowledgement of a fact under discussion or a material fact in a lawsuit. Now see, confessions is possible only in criminal proceeding, but admission can be applied to civil or criminal proceedings. Now if we look to the relevance, that confession must be voluntary to be relevant, but in admission, it need not be a voluntary to be relevant. Coming to the point of retractions, see, retraction is possible in confession, but retraction is not possible in admission. In general term, retraction means a withdrawal of a statement or a withdrawal of accusation or undertaking. Now, confession is especially made only by accused, but admission can be made by any person. Question number 4, which section of Indian Evidence Act 1872 provides that if a contract has been proved by writing, then no evidence can be given by any oral agreement as between the parties to contradict, to vary, to add to, or to subtract from its term. It is provided in section 92 of Indian Evidence Act 1872. Coming to question 5, which section of Indian Evidence Act 1872 provides that confession made by any person while in custody of police officer is not admissible unless it is made in the immediate presence of a magistrate? It is provided in section 26 of Indian Evidence Act. Question number 6, which sections of Indian Evidence Act 1872 provides that the facts are relevant even though they are not in issue if they form a part of the same transaction? It is provided in section 6 of Indian Evidence Act. Question 7, what is leading questions? Leading questions literally means a question which itself suggests answer. It is provided in section 141 of the Indian Evidence Act 1872. Leading questions in another term, in a simple term, we can say it is a yes-no questions. Suppose for examples, are you there at the home when the murder occurred? Then you have to respond in two ways, whether yes or no. This type of questions are said to be SL leading questions, and it is generally asked in a cross examinations. Question number 8. What is extrajudicial confession? See, a free and voluntary confession of guilt by a person accused of a crime in the course of conversation with person other than judge or magistrate or police officer. Since it is not made in judicial custody, such a statement, whether oral or written, is admissible as evidence in a criminal case. It is given in section 164 of Indian Evidence Act 1872. Question number 9. What is relevant fact? One fact is said to be relevant to another when the one is connected with the other in any of the ways. Under the provisions of Evidence Act, it is defined in section 3 and section 5 of Indian Evidence Act 1872. Let us see an illustration. A is accused of the murder of B by beating him. Whatever was said or done by A or B or bystanders, that means the one who is standing at the scene of that act, at the beating, or so shortly before or after it, as to form part of the transaction, is a relevant fact. Question number 10. Relevancy and admissibility under the Indian Evidence Act are neither synonymous nor coextensive. It generally means relevancy and admissibility cannot be taken as a similar terms. They are different under the Indian Evidence Act. Question number 11. Self-regarding statement can be self-serving or self-harming. Question 12. What is correct as regards the admissibility of self-regarding statements? Self-harming statements is admissible, but self-serving statement is not generally admissible. Question 13. Law of evidence is lex fori. The meaning of lex fori means the law of the country in which an action is brought. Question number 14. Fact can be physical as well as psychological fact. Question 15. Presumption under the law of evidence are presumptions of fact and presumptions of law. Presumptions of fact is based on logic, human experience and law of nature, while presumptions of law is based on provisions of law. Question 16. Dying declaration denotes the statement by a person as to cause of his death or as to any of the circumstances resulting in his death. It is provided in the section 32 of Indian Evidence Act 1872. Question number 17. Test of identification period for identification of accused by witness is relevant under section 9 of Indian Evidence Act 1872. Question 18. Relevancy of dying declaration is illustrated by illustration A to the section 32 of Indian Evidence Act 1872. Question number 19. The Kashmira Singh vs. State Madhya Pradesh is a leading case on confession to police officer. Question 20. Among motive, attempt, conduct and preparation, which is not relevant in civil and criminal case under section 8 of Indian Evidence Act 1872. Preparation is not relevant in civil and criminal case. Question 21. A intentionally and falsely leads B to believe that certain land belongs to A and thereby induces B to buy and pay for it. The land afterwards becomes the property of A, and A seeks to set aside the sale on the ground that at the time of the sale he had no title. He will not be allowed to prove his want of title. Which sections of the Evidence Act is applicable? By doctrine of estoppel under section 115 of Indian Evidence Act 1872. Question 22. What is the provisions of section 27? It says, when an information given by accused in police custody leads to discovery of material objects like jewelry, weapons, etc., then this portion, that is physical fact of the information, is admissible and the psychological fact discovered is not admissible. Here section 27 is the exemption of the section 24, 25, 26 of Indian Evidence Act 1872. Question 23. Section 26 of Indian Evidence Act 1872 provides confession made by a person in police custody is not admissible, but confession made in the immediate presence of magistrate is admissible. Question 24. The term evidence means and includes oral evidence, documentary evidence, and electronic records produced for the inspection of the court. Question number 25. Disputed handwriting may be proved either by calling an expert under section 45 or by examining a person acquainted with the handwriting of the person by whom a questioned document is alleged to have been written under section 47, or comparison of the two under section 73. Question number 26. Proof of fact depends on not upon the accuracy of the statement but upon the probability of its existence. Question number 27. Alibi is governed by section 11 of Indian Evidence Act 1872. Question 28. Section 13 of Indian Evidence Act applies to both corporeal and incorporeal rights. Question 29. Person who can make admission are mentioned in section 18 of Indian Evidence Act 1872. Question 30. Confession caused by inducement, threat or promise is contained in section 24 of Indian Evidence Act 1872. Question 31. Necessity rule as the admissibility of evidence is contained in section 32 of Indian Evidence Act 1872. Question 32. Oral evidence under section 60 of Evidence Act may be direct only. Question 33. The relationship in a section 50 of Evidence Act means relationship by blood or. Question 34. The circumstances under which the secondary evidence is admissible have been enumerated in section 65 of Indian Evidence Act 1872. Question 35. Secondary evidence is admissible where the non-productions of primary evidence has not been accounted for. Question 36. Public documents are mentioned in section 74 of Indian Evidence Act 1872. Question 37. Admissibility of electronic record has been prescribed under section 65B of Indian Evidence Act 1872. Question 38. Section 91 of Evidence Act applies to transactions which under the law must be in writing and which are reduced into writing voluntarily. Question 39. The test of ascertaining on which side the burden of proof lies is contained in section 102 of Indian Evidence Act 1872. Burden of proof means, as a matter of law and pleading, is burden of establishing a case and introductions of evidence. Question 41. Burden of proof under section 101 of Evidence Act never shifts, that means never changed. Question number 42. Section 105 of Indian Evidence Act 1872 applies to criminal trials only. Question 43. An accomplice is a competent witness against an accused. Question 44. Presumption under section 113A of Evidence Act can be raised if the suicide by the married woman is committed within 7 years of marriage. Question 45. Section 108 of Indian Evidence Act 1872 relates to presumption of death. Question 46. For presumption under section 107 of Evidence Act, the person is to be shown to be alive within 30 years. Question 47. Presumption under section 112 of Evidence Act 1872 is raised when the child is born during the continuance of a valid marriage, or when a child is born within 280 days of dissolution of marriage and the mother is remaining unmarried. Question 48. A dumb person is a competent witness as provided under section 119 of Indian Evidence Act 1872. Question 49. Leading questions can be asked during cross-examination. Coming to last question, question number 50. Court can permit leading questions during examination in chief or re-examination if they refer to the matters which are introductory, undisputed and sufficiently proved. Thank you for watching Ask Me Anything. Please do like, share and subscribe to support my channel Ask Me Anything. Your one subscribe will give me a new platform of teaching. If already subscribed, then thanks for your subscription. And press the bell icon to get interesting questions and latest updates.